You know the law, you've cited your rights, but the officer just doesn't care. It is the single most frustrating situation in civil rights advocacy, when the rules are clear, but the police break them anyway. Most of us were raised to believe that if a cop doesn't read you your Miranda rights, the case gets tossed or you can sue them for a massive payday. But here is the cold, hard truth. The Supreme Court recently ruled in Vega versus Tekoh that you actually cannot sue a police officer for a Section 1983 civil rights violation just because they failed to give you a Miranda warning. It might keep your statement out of trial, but it won't get you a cent in a lawsuit. So what do you do when the system fails to follow its own playbook? Today, we're moving past theory and getting into the exact legal steps you must take to protect yourself when the law is ignored. Most people think they can win the argument on the side of the road by quoting the Constitution. They are wrong. Your survival and your future lawsuit depend on three things: staying silent, recording the truth, and knowing the strict deadlines that can kill your case before it even starts. If you are stopped, whether on foot or in your car, the most dangerous thing you can do is resist or badmouth the officer, even if you are 100% innocent. The law grants police enormous power, and resisting an unconstitutional search or arrest can often lead to additional charges that will stick, regardless of whether the original stop was legal. The mantra is, stay calm and comply, but do not consent. If an officer asks to search your car, don't just say no. Say, I do not consent to a search. Why? Because if you just say no, they might argue in court that you didn't really mind. But the word consent is a specific legal standard they have to overcome. While you are standing there, your best friend is your phone. You have a First Amendment right to record police officers performing their duties in public spaces. They cannot order you to stop just because you're recording. They might tell you to move back for public safety, and you should follow that order to avoid an interference charge, but you can keep the camera rolling from a safe distance. Crucially, the police cannot confiscate your phone or demand to view your footage without a warrant. If they try, you have the right to refuse to unlock your phone or provide your passcode. But here is where most cases are won or lost: documentation. There's a common myth that an officer is legally required to give you their badge number on demand. While many departments have policies saying they should, it's not always a hard and fast legal requirement. Instead of arguing about it, try to spot the badge number yourself, or look for the patrol car number. Write down everything: the time, the location, the names of witnesses, and exactly what was said, as soon as the encounter ends. If you were physically injured, go to a doctor immediately. Photos of bruises and scrapes are evidence, but medical records from a professional carry far more weight in front of a jury. Once the dust settles, you have a ladder of accountability to climb. The first rung is often an internal affairs, IA, complaint, or a civilian review board. Be warned, though, internal affairs investigations are notoriously biased toward the officer. They are internal and often secretive. If you plan on filing a serious lawsuit, you must talk to an attorney before you give a statement to internal affairs. Anything you say to them can be used against you later to twist your story or point out inconsistencies. If the misconduct is systemic, meaning it's not just one bad apple, but a pattern of the whole department breaking rules, you can file a complaint with the U.S. Department of Justice, DOJ. The DOJ has a civil rights division that can investigate entire agencies to see if they have policies or practices that violate the Constitution. They don't act as your personal lawyer, and they won't get you money, but they can force a city into a consent decree, a court-ordered reform plan with federal oversight. But if you want justice for yourself, you're looking at a civil suit. Most people think you just sue the police, but there are actually two different paths depending on who stopped you. If it was a state or local officer, you sue under a law from 1871 called Section 1983. If it was a federal agent, like an FBI or Border Patrol agent, you have to bring what's called a Bivens action. Bivens actions are much harder to win because they aren't written in a statute. They are implied by the court and have been getting narrower and narrower over the last 40 years. This brings us to the biggest obstacle in civil rights law: qualified immunity. This is a judge-made doctrine that says you cannot sue a government official unless the right they violated was clearly established. This doesn't just mean the Constitution says they can't do it. It often means you have to find a previous court case with almost identical facts where an officer was already found liable. In one case, a man was bitten by a police dog while he was sitting on the ground in surrender. The court had already ruled it was illegal to use a dog on a man lying on the ground. But because this man was sitting, the court granted the officer immunity because the facts weren't exactly the same. Because of hurdles like qualified immunity, you might want to look at a Monell claim. Instead of just suing the individual officer who might not have any money anyway, a Monell claim allows you to sue the city or the police department itself. To win this, you have to prove that the officer's bad behavior was caused by an official policy, a widespread custom, or a complete failure to train officers in an obvious area. Finally, you need to watch the clock. This is the most heartbreaking way to lose a case. Every state has a statute of limitations, a strict deadline to file. In some places, like New York, if you want to sue the city, you have to file a formal notice of claim within just 90 days of the incident. If you miss that 90-day window, your case could be dead before you even find a lawyer. To truly protect your rights when they are being ignored, you must become your own best advocate by mastering the details that the police hope you'll overlook. It begins by remaining calm and recording the encounter from a safe distance, a First Amendment right that provides the objective evidence needed to overcome a he said, she said battle in front of a jury. Even if you cannot stop an officer on the street, you must clearly state, "I do not consent to a search," which preserves your Fourth Amendment protections for the courtroom later. Documentation is your greatest weapon, so you must record every badge number, patrol car ID, and witness name immediately after the encounter ends. You cannot afford to wait, as strict procedural hurdles, like New York's 90-day window for a notice of claim, can destroy even the strongest case before it ever reaches a judge. Finally, understand the limits of the law. While a Miranda violation might help your criminal case, the Supreme Court has ruled it generally won't win you a civil rights lawsuit. By staying silent at the scene and speaking loudly through your evidence later, you ensure that a single night of police misconduct does not turn into a lifetime of denied justice. If you found this legal breakdown helpful, please like this video and subscribe to the Legal Lecture to stay informed and protected.